And I'll say this one more time, just to clarify again. I wish I could clarify it in just one video, but it's hard when you're thinking from like your mind and you're speaking it. It's kind of hard to. But basically, you have to attack the presumptively lawful aspect of the felons and the mentally ill standard with the Supreme Court dicta and Heller. You have to. Like I said, most courts won't go past that statement from the Supreme Court. And that's the problem, which is why you can't win your cases because of that statement alone. If you physically have the antique firearm or the stun gun, and you can present that in court, it forces the government to use that evidence to go against what the Supreme Court said under that standard. It kind of contradicts the standard that you don't have a Second Amendment right if you're using an arm that is protected by the Second Amendment. Basically, it's going against what they said, and you're demonstrating that you're outside the bounds of the people that are typically prohibited from using these types of arms. Like I said, it's a one-dimensional type thinking to believe that you only have a constitutional right to firearms when in reality you have a constitutional right to any arm that is bearable. That is the key difference. So you have to physically have the arm, or you don't have a defense to prove that you're safe to use a firearm in your case when you're filing an injunction against the government. It's key. I understand that your injunction is about you possessing a firearm under the Second Amendment, but you have to demonstrate that you have a Second Amendment right in the first place. In order to do that, you have to have the right to bear arms. And again, you're putting the government in a position where you're showing them that you still have a right to bear arms, because statutorily speaking, you're still bearing an arm statutorily because you're bearing a stun gun or an antique firearm, which is still legal under federal law. Because it's still legal, you've demonstrated that that your right couldn't have been affected because you still statutorily have this right to bear this type of arm, as opposed to 18 U.S.C. 922 G4 is only barring you from possessing modern ammunition and firearms. So again, keep that in mind. Use the antique firearm and a stun gun as reference to you possessing arms legally and constitutionally. I know I keep saying that, but you have to do it. You have to. I'm going to keep saying it. You have to keep doing that, or you will lose your case. Just letting you guys know that ahead of time. Again, just to let you know. So yes.